Uh, We need procedures that translate the values of the Fourth Amendment with its warrant requirement into a new technological context. Do you agree or disagree with this claim by a legal scholar, and why? What values are inherent in the Fourth Amendment, and why are they important? Some scholars argue that government can use surveillance data collection and data mining technologies for good purposes, such as keeping America safe from terrorist attacks, preventing crime, and delivering social services. Do such uses outweigh possible negative uses? Why or why not? And you may begin.
Justice Brandeis spoke of an evolving constitution when he wrote in Olmsted v. U.S., "A principle to be vital must be capable of a wider application than the mischief which gave it birth." We agree with Justice Brandeis and Jack M. Balkin, and we believe that we must translate the values of the Fourth Amendment into a new and technological context.
To fully understand why the Fourth Amendment must be adapted to keep pace with technology, it is first necessary to understand the intent of the framers and what values are inherent in it. The colonists were often subjected to oppressive practices by the British government, notably the writs of assistance. These broad, general warrants filled colonists with the desire to keep man's home his castle, as James Otis famously stated, and ultimately led to the creation of the Fourth Amendment.
One of the values at the core of the Fourth Amendment is limited government. Today, the amendment both limits the government from intruding without probable cause and safeguards safe procedural due process through the exclusionary rule established in Weeks v. United States. The concept of reasonableness of a search is also inherent in this amendment. There must be a sufficient connection between the reason for a search and the nature of government intrusion.
Though the right to privacy is unenumerated, we believe it is inherent in the Fourth Amendment, as found in Griswold v. Connecticut and Roe v. Wade. In Griswold, Justice Douglas implied privacy to be found within the First,
Third, Fourth,
Fifth,
And Ninth Amendments.
as well as the Liberty Clause of the 14th Amendment.
We believe that today we must take the inherent values in the adoption of the Fourth Amendment and translate them into a new and technological context. As technology changes, so do the standards for reasonableness of searches. Therefore, the courts must analyze those situations in which the invasion of privacy is preferable to letting crimes go unpunished. In Katz v. U.S., wiretapping was ruled unconstitutional, but in U.S. v. White, wiretapping was allowed if one person in the telephone conversation was an undercover police agent.
In Florida v. Riley, the court ruled that no warrant is necessary to view property from public airspace. Yet in Kylo v. U.S., it was ruled that a warrant is required to use a thermal imaging device outside of a home. Ultimately, the court must continue to rule on cases dealing with the Fourth Amendment and technology to answer the concerns of protecting privacy, while also allowing law enforcement to make use of valuable technologies to do their jobs.
We believe that using data collection to keep Americans safe from terrorist attacks, prevent crime, and deliver social services can outweigh possible government abuses. In his essay, The Constitution in a National Surveillance State, Jack M. Balkin recognizes that the Fourth Amendment places few limits on data mining and does not require the government to discard any stored information. We feel that such freedom on the part of the government can result in a more secure nation. An example is provided by the extensive allowance of data mining in the Patriot Act. Though many believe this legislation to be an invasion of privacy, we must recognize that we have not been successfully attacked on American soil since its passage.
The government also uses data mining to prevent threats to personal security of citizens by preventing crime within our borders. Criminal databases and facial recognition software gives law enforcement many advantages in identifying and eliminating threats in advance.
Another benefit to government data collecting is the ability to provide social services like Medicare, Medicaid, and Social Security. While we believe that the majority of these technologies can be used for good, we do recognize that we must be wary of becoming an Orwellian society that has given up everything in the name of security.
There is a delicate balance between the protection of the common good and limiting the government power by protecting civil liberties. We must protect ourselves, but we should continue to abide by the intent of the framers and limit the government. For in the words of Justice Potter Stewart, the Fourth Amendment and the personal rights it secures have a long history. At the very core stands the right of a man to retreat into his own home and there be free from unreasonable government intrusion. This concludes our statement, and we are now ready for your questions.
Actually, did I hear you say that preventing crime can outweigh government abuses in your opening? Did I hear that incorrectly?
Yes, we said that it can outweigh sometimes.
It can outweigh.
any of you advocating an alteration of the prohibition against general warrants?
No, I don't believe that any of us would ever take such a drastic step.
And you're all for searches and seizures being reasonable?
Yes.
You're all for the requirement of a warrant to support a constitutional search or seizure in the absence of a generally recognized exception to the warrant requirement. Is that correct?
Yes.
You're all in favor of requiring probable cause to support the issuance of a warrant permitting a particularized search and seizure, isn't that so?
Yes.
So what's new?
The technology is new. The technology that we're using to make these searches today is new. Hannah mentioned the case Kylo v. US. Thermal imaging devices were not around when the Fourth Amendment was written, and these new technologies are what is new, and that's why we need to adapt the Fourth Amendment to protect ourselves from these new technologies that are more invasive.
And how do you do that? For instance, emails. You're a student at a public university, and it's supported with government money. Do you give up your right to privacy in that context? I mean, you're taking government money and you have email. Can the government come in and look and see what you have been emailing other people without a warrant?
I would say that in that case, you have very little expectation of privacy, so yes, I would say that would be okay.
Why?
Well, I think that you would have no expectation of privacy because since the
I'm
government...
sorry, did you say less expectation?
Yes, I said less. Yeah, I think that because if it is email issued by, let's say, the university, then you are using their money. They're providing you with the email, so I think they should have the right that if they need to, they can look into your emails because they are providing you with that service.
I have to disagree with my friends and say that no, that you have an expectation of privacy with your email. To me, an email is still a letter, as ruled in Ex parte Jackson. The government cannot open your letters, and to me, email is just another form of a letter, just delivered electronically.
At the same time, letters that Laura mentioning, physical mail is operated by a government service, and email is run by private companies. So although you might not have an expectation of privacy from the private company, I feel that though this is really ruled null and void under the Patriot Act, I feel that your email should be more private.
Because the Patriot, I'm sorry.
So do we take the same position with respect to Facebook profiles?
I do not. Facebook profiles is more of a public forum, and it's a place where you are putting information about yourself out into a public chat room. To me, it's very similar as sitting in a park and talking with your friends.